Hi, I'm Ben Schwartz. Today we're going to answer a viewer question. A guy named Rod wrote in, and Rod said, essentially, I have a personal injury case going. I've got an attorney, and I need to get some money now. And how can I do that? Should I get a lawsuit loan? And so I thought this is a really good question. It's a question that comes up quite often, in my own legal practice, where I'll be representing someone in a personal injury case. And these personal injury cases typically take a minimum of several months, a maximum of several years to resolve. And people don't want to wait to get their money. People want to get their money now. I don't think it helps that there's like a TV commercial on television right now as we record this video that has people like hanging out the window yelling, "It's my money, I want it now." If it's a personal injury case, it's not guaranteed money, and it really isn't your money until you get it in your hands. And so getting it now may not be the best thing in your case, in your situation. I just wanted to do a sort of a general information video on this topic of lawsuit loans in personal injury cases. When you have a personal injury case pending, you can go to a lender, and there are lenders that specialize in what's called non-recourse loans. They loan money to people who have a pending car accident personal injury case or a pending slip and fall personal injury case. And what they are doing is they're appealing to consumers who have personal injury cases, and they're telling consumers who have personal injury cases, listen, we can loan you $500, $1,000, $2,500, and if you win or settle the case, you pay us back. And if you don't win or settle the case, you don't have to pay us back. It's called non-recourse funding. And if you want my opinion, it's about the worst deal you could ever think of. It's a complete and total scam, in my humble opinion. I have people that come to me and they say, look, my back's up against the wall. I need money to pay the mortgage. I need money to pay rent. I have a personal injury case pending with your office. Why don't you help me complete the paperwork and do this loan? And I always tell them, it's a bad idea. Get the paperwork and let's have a look at it. When we get the paperwork, what you see is this is how much we're going to loan you on this case. This is how much you're going to pay back. If you go in and calculate, pull out your calculator and calculate what the actual interest rate is on the money that you're borrowing as part of a non-recourse lawsuit loan, it's absolutely staggering. As I'm recording this video, I'm in the state of Delaware, and Delaware has very lax laws when it comes to usury. In other words, in Delaware, it's a legal environment that's very friendly to banks, credit card companies, and other lenders. And if you ever want to see a state where predatory lending is allowed to exist, the state of Delaware would probably be the place to look because the laws are so favorable to the lending industry. The problem is, from my perspective, that the interest rate on these non-recourse loans is so incredibly high that if you get any money from a non-recourse personal injury loan, by the time the case settles and you have to pay that money back, you probably are going to owe back more than you're going to get out of your personal injury lawsuit loan. And what I like to do is I like to get the paperwork, I like to sit down with my clients and go over the numbers, explain how interest works, show them what their real interest rate is going to be, and then we talk about, you may be paying 400% APR on one of these non-recourse loans. I'm paying 4%, not 400% on my home mortgage. Why is it that I'm paying 4% when this company wants to loan you money and they want you to pay 400%? Like if we went to McDonald's and I got a Big Mac and I paid $5 for my lunch, Would it be fair for McDonald's to say to you, well, you have to pay $500 for your lunch? That's ridiculous. It's completely unfair. So from my perspective, it's a terrible situation. I don't want my clients to have to put themselves into that situation where really they're being victimized twice. You've been victimized once if you've got a personal injury case. You were minding your own attention and you're minding your own business, paying attention to the road, and someone who wasn't paying attention rear ends you. You've been made a victim. Well, why would you want to voluntarily become a victim again of a predatory lender who's going to charge you an interest rate in the hundreds of percentage points on an annualized basis? It just doesn't make any sense. What I tell people is, if you need money, your best bet is to go to friends and family and borrow money. Your next best bet would be to use the financial resources that you have available to you, such as a personal loan from a bank, a second mortgage on a home, credit cards. The only time you would ever want to use non-recourse funding and get a loan that you have to pay back out of a personal injury settlement is basically if your back is truly up against the wall and there is no other alternative and you're not going to be able to put food in your kids' mouths and there's no other alternative. That's when you would use this. But quite frankly, in a first world country, I don't see a need for it. So I realize that's a lot of opinion, and I hope that this video is something that if you're watching it, you can use it and find it helpful, and maybe it can give you some guidance if you're considering contacting one of these lawsuit lenders. It really is something that people don't talk about. In my opinion, people don't talk about enough. A few years ago, I was at a state trial lawyers convention and the topic came up. Several hundred attorneys in a room at this convention hall, at a presentation, and the topic came up, and I raised my hand and I said, I always tell my clients, we don't do that. It's a terrible idea. The other attorneys in the room basically told me that I'm a jerk for standing in my client's way of getting their money. But I think they don't understand basic finance, because anybody with a brain is going to know if you help your client sign up to a 400% or 600% APR loan, you're not doing them any favors. What are you doing? You're harming your own client. I think it's a terrible idea. I'd be interested to know what you think. If you've had an experience, if you're an attorney and you've had an experience where your client has gotten a lawsuit loan and had a successful experience and the lawsuit lender didn't steal all the money from their settlement, I'd be interested in knowing about that. If there are non-recourse lenders out there that are treating consumers fairly, I'd be real interested to know about that. If you are someone who has had a personal injury case and you obtained a loan and then paid it back out of the personal injury case, you had a bad experience, you had a good experience, I'd be interested to know about it. I'm trying to remain open-minded on this topic, but at the same time, I see a lot of abuse in the lending and in the financial industry, and I think it's got to stop. I'm attorney Ben Schwartz. Hope you found this informative and entertaining. Leave us a comment and let us know what you think. And if you have a question about personal injury law or litigation, send me an email. My email address is ben.schwartz@schwartzandschwartz.com.